live in a world that has tough toys being real things and monsters.
I think Alan Page said, or someone like that, like, the society would be a whole lot better if we just stop, or like we just start being less horrible to each other in a very simple manner. But I just wanted to also talk to you about like which you talked about, like I think a little while back, about the legal rights, right? Like I think this whole book of legal rights, and I'm curious to know. Of course, I'll talk to you about the same-sex marriage, which was so much in the news in a little bit. But what are some of the most important legal rights which queer folks are constantly being denied in this country, for example? And now is the time you feel like it's 2024, we should have these rights. Why don't we have that anymore?
I think three things: anti-discrimination, long overdue, doesn't exist. It's a right that you share in common with other marginalized communities, but protection against discrimination in housing, in employment, in access to government services is incredibly important. So a comprehensive anti-discrimination law is definitely incredibly important. I think the second thing is sort of horizontal reservations for transgender people. Grace Banu has been arguing for this a lot. I think we've got a stage in which you've gotten widespread agreement on the need for affirmative action for trans people. What you haven't seen is an effective policy engagement of affirmative action for trans people with affirmative action on lines of caste and what to do when those two intersect. So why should a Dalit trans person be only under Dalit or trans? They should have the option to be expressing their identity within the law as a Dalit trans person. And so the horizontal reservations aspect is very important. And I hope the government, after having trans people invited to the swearing-in ceremony, will take up the actual concerns of the trans community also seriously and effectively. And the third is a recognition of unions, right? And this could be marriage, this could be a civil union, this could be a partnership, this could be a live-in relationship, whatever you choose to call it. But you need a recognition of union, and I take a different stance than most others on this, and I don't see it as a need for a granting of rights. But I see it as a important step in ensuring access to protections, right? That when queer unions are recognized, it means that queer couples running away from home have the weight of the law, even when they're consenting adults, to say that they cannot be persecuted by their families. And today, unfortunately, the grim reality is that when queer couples do run away, and there are adults involved on both sides, the police still go after the couples because they have like parents who charged one of the other with kidnapping, right? And this is a setup that we have recognized over the years very effectively with interreligious and intercaste marriages. Today, every police officer knows that if they listen to the demands of the parents of one side of an intercaste couple and break up that couple, the courts will come down heavily on them. Even though there's been a limited understanding of that with queer couples, where the courts have said time and again that queer couples who are consenting adults have the right to cohabit and live together despite what their families think, time and again. It's not as easily legible and as widely understood as the concept of a marriage or a sort of relationship that's recognized by the law. And so you need that union to ensure access to protections. So that when people are running away from home, and there's a great intervention that was filed on natal family violence in the Supreme Court marriage equality verdict, which dealt exactly with this. It said that we don't want marriage because it's giving us like the right to buy a house together. We want marriage because it's giving us the right to not be hunted down by our families when you run away with each other. And so I think those three are the three top priorities in terms of any form of legal change in the next 10 years.
Yeah. And picking up the third one like a little bit more, right? Think when the same-sex marriage was being heard at the Supreme Court, I think it was Justin Narasimha, and I want to get it right, who said marriage equality for LGBTQIA never arose in this court and thus no precedent. Right of LGBTQIA is gender identity, right to sexual orientation, right to cohabit, and they have full freedom in the same. No unqualified right to marriage, and it is not a fundamental right. So essentially the question is, not a fundamental right. So how did you look upon the judgment, and what do you think about it?
The court in all of its wisdom has held that the right to marriage is not a fundamental right. Now there are differing opinions on this. There are lawyers far smarter than I am who've opined effectively on the matter and said that the right to marriage not being a fundamental right puts protections for intercaste and interreligious couples under threat as well. That being said, the court's observation that marriage is not a fundamental right, but that other fundamental rights are available to queer couples, is a building block for showcasing to the court its own inability to understand the petitions put before it. I think the court has fundamentally misunderstood the demands being made upon it, and the judges in all of their wisdom have not understood what was being asked for. If you say that all other fundamental rights are being granted to queer couples, if the title of marriage is the only thing that is preventing queer couples from accessing some of those other fundamental rights, then your denial of marriage or a substitute thereof, by claiming that there is no fundamental right to union, is a direct denial of fundamental rights to queer couples. And so the court can't say, oh yes, like everyone has the right to drink a glass of water, but not everybody has the right to a glass. So only those with a glass can be able to drink water. Right? So you can't, then you're not like, but we are not giving everybody a glass. Right? And we're not even giving somebody the ability to put their mouth to the tap to drink directly from it. You can only drink water if you have a glass. So now today I have the right to drink water, but I need a glass to drink water. And the court has said, but you don't have a right to a glass. So the court is guilty of engaging in complex legal gymnastics to make a very valid legal argument.
Of course.
I think the judgment is legally watertight, but it comes through with the legal gymnastics that mean it is not. And I don't want to say this, which is why I said I hope that the judges have misinterpreted what the demands before them were, because otherwise the only viable explanation is that they have had a lack of good intent. And I think that is something that they will have to live with on their own conscience, because this is either a misunderstanding of the demands placed before the court or a lack of good intent. The lack of good intent is something that they and their conscience should live with. But I think you've gotten a situation wherein the possibility, unless review petitions before the court do better than one has expected them to do, you've gotten the possibility of a long fight ahead for any recognition of union, because it will now have to come through the legislature rather than through the courts. And how that unfolds, where that unfolds, does that potentially unfold through a UCC, will be left for us to find out possibly in the next few months.